The first 48 hours after arrest often determine the entire outcome of a criminal case. I'm retired New York Supreme Court Justice Michael Torres, and after 20 years presiding over criminal cases from arraignments to sentencing, I can tell you that what happens in those crucial first hours sets the tone for everything that follows. Let me show you how to navigate these critical initial proceedings and protect your rights from the very beginning. First, understand New York's criminal court structure. Local criminal courts handle misdemeanors and the initial stages of felony cases. This includes city courts, town and village courts, and district courts. These courts conduct arraignments, preliminary hearings, and trials for misdemeanors. Supreme Court handles felony trials and sentencing. But here's what confuses people. Even felonies start in local criminal court for arraignment. The case only moves to Supreme Court after indictment by a grand jury or waiver of that right. Now let's talk about arraignment, your first and most critical court appearance. Under CPL 180.10, you must be arraigned without unnecessary delay and for warrantless arrests. That means within 24 hours of arrest, not counting Sundays and holidays. At arraignment, several crucial things happen simultaneously. The charges are formally read, you enter a plea, bail is set, or you're released on your own recognizance, and your right to counsel is addressed. Miss any of these elements, and the arraignment is defective. Here's what I've seen from the bench. Most people focus only on bail, but the plea is equally important. You typically plead not guilty at arraignment, preserving all your rights and defenses. Don't even think about pleading guilty without counsel unless the charge is a simple violation. For bail decisions, New York's Bail Reform Act has fundamentally changed what judges can consider. We can no longer set bail simply to protect public safety. Bail is only allowed for specific enumerated offenses, and even then, it must be the least restrictive means to ensure your return to court. I consider your ties to the community, your history of court appearances, the seriousness of the charges, and your ability to pay. What I cannot consider anymore is whether you might commit new crimes. This is a huge change from pre-2020 practice. The right to counsel attaches immediately at arraignment. If you cannot afford counsel, the court will assign an attorney through the local assigned counsel plan or public defender's office. This isn't charity. It's your constitutional right under the Sixth Amendment. But here's what many people don't understand. The quality of assigned counsel varies dramatically by county. Some public defender offices are excellent, others are overwhelmed. If you can afford private counsel, especially for serious felonies, it's often worth the investment. Financial eligibility for assigned counsel is determined by court guidelines, but there's often flexibility. Don't assume you don't qualify. Let the court make that determination based on your actual financial circumstances. Now about timing and deadlines. The prosecution has strict timelines under CPL 180.80 for filing informations and conducting preliminary hearings. For felonies, they must file a felony complaint and move toward grand jury presentation or preliminary hearing within specific timeframes. From my experience on the bench, cases often get dismissed because prosecutors miss these deadlines. Pay attention to them and make sure your attorney files appropriate motions when the people fail to meet their obligations. Here's practical advice for anyone facing criminal charges. Treat your arraignment seriously even if it seems routine. Dress appropriately, arrive early, and speak only when asked direct questions by the court. Your behavior at arraignment influences my impression for the entire case. If you're representing yourself, which I strongly discourage for anything beyond simple violations, request an adjournment to obtain counsel. Almost every judge will grant this request because we'd rather deal with represented defendants. For family members attending arraignment, understand that this is often your only chance to provide character information for bail purposes. Bring documentation of community ties, employment, and family responsibilities. These factors matter in bail decisions. The conditions of release set at arraignment are crucial. Violate them and you'll likely be remanded without bail. Common conditions include staying away from victims, surrendering passports, and checking in with pretrial services. Take these seriously. Remember, arraignment is just the beginning. What happens there affects plea negotiations, trial strategy, and sentencing. Get it right from the start, and you're positioned to fight effectively throughout your case. Attorney Washington will now explain how to protect your constitutional rights during the arrest and investigation process.